Nelson Tree Service versus Randall Gray and Owen Specialty Services Incorporated. Counsel for the appellant, when you're ready, you may proceed to the podium.
Good afternoon. My name is Angelique Lyons, and I represent the appellant, Nelson Tree Service. I'd like to reserve 4 minutes for rebuttal, please. Nelson is appealing the lower court's ruling denying its motion for temporary injunction. This case arose from an employment relationship where Mr. Randall Gray, one of the appellees in this case, was a regional manager for Nelson, had a non-compete agreement, left his employment with Nelson, and went to work for a competitor. Nelson sought to enforce the provisions of the non-compete agreement, and in so doing filed a motion for temporary injunction, which was denied by the lower court. The lower court held that Nelson did not prove irreparable harm, which is an element necessary to be granted a temporary injunction. This finding by the lower court is not reasonable given the clear and convincing evidence presented by Nelson during the hearing. This case is controlled by Ohio law due to a choice of law provision in the contract.
What's the standard of review on this case?
Well, for the first point of appeal, Your Honor, the standard of review is it's subject to abuse of discretion standard, where the lower court's ruling finding there's not irreparable harm should only be overturned if no reasonable person would have found otherwise. Would have found consistent with the judge, Your Honor. And even given that heightened standard, the trial court erred in its finding. To prove a temporary injunction under Ohio law, a party is required to show 4 things: likelihood of success on the merits, irreparable harm, impact on public interest, and possibility of substantial harm to others. The trial court found that Nelson proved the first element, likelihood of success on the merits. Although the court did not elaborate on this finding, inherent in a finding that Nelson would succeed on its breach of contract claim is a finding that the contract was reasonable and that Mr. Gray had breached the contract. The next point, the trial court erred when it found that it did not find irreparable harm. Nelson had the burden to prove irreparable harm. And under Ohio law, an actual threat of irreparable harm is enough. There are 2 ways Nelson could and did prove irreparable harm. The first is by showing that the employee, Mr. Gray in this case, possessed knowledge of trade secrets. In that situation, the Ohio cases clearly state that irreparable harm will be presumed. But the Ohio courts take it one step further. When the employee possesses knowledge of trade secrets and then goes to work for a direct competitor, the Ohio courts have stated that the irreparable harm is proven. So we're not having a situation of presumed harm. It's proven if Nelson showed 2 things. 1, that there was confidential trade secret information known by Mr. Gray, and number 2, that he went to work for a competitor. In this case, there was clear and convincing evidence presented to the trial court that Mr. Gray did have knowledge of trade secrets while he worked for Nelson, where he was a regional manager. The trade secret information included bidding processes and spreadsheets, job tracking programs, bid amounts and values, contract prices, and Nelson's business and marketing plans. What Nelson does is they bid on tree trimming work to trim trees away from utility lines. They get their work by going through a bidding process. So their bidding numbers, their profit margins, all of the data contained in these spreadsheets are very important to the company in securing their bids and constitutes trade secret under Ohio law. A trade secret under Ohio law is defined by 2 things. 1, it derives independent economic value from not being known to others or readily ascertainable by proper means. And number 2, that it's subject to reasonable efforts to keep it secret. The information known by Mr. Gray, including these spreadsheets, the data that goes into the spreadsheets, the profit margins of Nelson, the job tracking program, which is a separate computer program written by Nelson for Nelson, all of that information does have independent economic value and was subject to efforts to keep it secret. In his brief, Mr. Gray argued that the fact that Nelson is required by the state of Florida to submit some information contained in its spreadsheet, namely the cost of labor, what it's paying its employees, to the Florida workers' compensation people, that alone is enough to destroy its status as a trade secret. That is not true. That's one small piece of the evidence and one small piece of the information contained in these processes and formulas that are confidential and are germane to Nelson's business. As the Ohio court in Procter & Gamble stated, that even if some of the underlying data is readily ascertainable, the overall data and the overall analysis and interpretation of that data can still be confidential and a trade secret. The case of Provact Plant Services versus Glass, which is cited in our brief, deals with this exact same issue. The court there affirmed an injunction against a former general manager and vice president who used a customer list and past bid information to compete directly with his former employer. The court held that these documents were trade secrets. They were not revealed to competitors. They had independent economic value because to discover these secrets for someone else could be used to underbid the employer when jobs come up for rebid. The same thing was also present in the case of Vanguard Transportation.
Well, didn't the trial court basically find all this? You know, what the trial court found is that you didn't prove that there would be irreparable harm if the injunction was not entered, basically saying that at the end of the lawsuit, he'll be able to recover all of his damages, so we don't have to do an injunction here?
It's unclear exactly what the trial court's reasoning was. The trial court said there's not irreparable harm. Under Ohio law, if we prove trade secrets, if Nelson proved a trade secret, and Nelson proved that Mr. Gray went to work for a competitor, then we've proven irreparable harm. So the trial court's finding would be incorrect based upon the plain letter of Ohio law. Therefore, we've surmised by the lack of detail in the trial court's order that it did not feel there was a trade secret. Clearly, the evidence presented before the trial court showed by clear and convincing standard that these were trade secret information, and the evidence also showed that the trade secret information was kept confidential by Nelson to the greatest extent possible. The second element, that Mr. Gray went to work for a competitor, is clearly not in dispute. Mr. Gray admitted throughout the testimony at the temporary injunction hearing that after he left his employment with Nelson, he went to perform services for OSS. He wasn't getting paid. He was called a consultant. There's a whole bunch of different words they used to describe it. The end result was the same. Mr. Gray had an agreement with OSS, whatever you want to call that agreement, to do bidding work for them, which is the exact same work he had done for Nelson. So that element is clearly established by the record. Given the fact that Nelson proved that there are trade secrets that Mr. Gray had access to, and that Mr. Gray went to work for a competitor, it is proven irreparable harm necessary to sustain a temporary injunction.
Did you supply the trial court with the Ohio law to that effect?
Yes, Your Honor.
You did. You made those arguments as part of the summary, part of the legal argument in support of the motion for preliminary injunction, temporary injunction.
Yes, we submitted a proposed order to them that cited all those cases, Your Honor.
Okay.
And even if the court were to have found that there was not trade secret information, there's another way Nelson proved irreparable harm. Under Ohio law, a company can prove irreparable harm if it shows that the relationship with its customers was such that anyone undermining that relationship would have harm on the original company. In the case of Bassett Computer, the Sixth Circuit held that loss of customer goodwill often amounts to irreparable harm because it's difficult to compute. Similarly, loss of fair competition that results from a breach is likely to be irreparable harm to the employer. In this case, it was well established that one of Mr. Gray's job duties at Nelson was to establish relationships with the customers that Nelson would ultimately bid on. And the importance of these relationships were many, but one of them being that contracts were awarded more on just the bottom price that was submitted, but on the relationships and the knowledge of the customer with the person doing the bidding.
Counsel, I hate to interrupt, but you've got another argument on appeal.
I do.
And would you like to talk about that some?
I would love to talk about that stuff. The second issue on appeal is that the appellant moved for a temporary injunction against Mr. Gray's new employer, OSS. The trial court denied the temporary injunction because it stated that the appellant did not, in its original complaint, include a separate cause of action for temporary injunction against OSS. The Florida Rules of Civil Procedure at 1.610C provides that injunctions can be issued to parties and those in active concert or participation with them who receive actual notice of the injunction. In this case, the evidence was clear that OSS acted in active concert with Mr. Gray.
What would the injunction against OSS look like?
The injunction against OSS would prevent OSS from using Mr. Gray in any capacity whatsoever to violate the non-compete, i.e. to compete directly with Nelson, or the data that Mr. Gray has supplied OSS through his year employment with them at this point.
What I'm suggesting is that were you to be successful, and it seems to me the only difference in the injunction against the corporate entity would be to bar the corporate entity from using data it has already obtained in the past. Is that right or wrong?
It would bar them from using the data that they've already improperly obtained and would bar them from employing in any capacity Mr. Gray.
That doesn't really amplify. If you were successful in an injunction against Mr. Gray, he'd be barred from being employed by OSS. It's the other same side of the other side of the same coin.
Correct.
So the difference is use of that, whatever that information is that he may or may not have already imparted to OSS.
Correct, Your Honor.
And does it, I'm not sure I understand your argument to the extent you say that the rules of civil procedure permit non-parties also to be enjoined under certain circumstances. That wasn't the basis on which the trial court denied relief, was it? As to OSS, the basis was you hadn't named them in the complaint.
No, Your Honor. They were named in the complaint. The basis was that the complaint didn't state a separate cause of action seeking an injunction against OSS.
And did you argue to the trial court, we don't have to do that?
Yes, Your Honor.
It's sufficient to identify in the motion for temporary injunction that we want to enjoin OSS too, provided that they receive adequate notice of that? You argued all that to the trial court?
We argued all of that, Your Honor.
Okay.
And I see that I'm into my rebuttal time, so I will reserve the rest of my time for rebuttal.
Mr. Ireland.
May it please the court. My name is Leonard Ireland. I represent OSS and Randall Gray. Judge Monaco got it right. He did exactly what the evidence in this case showed and the lack of evidence in this case showed. He comes here with a presumption of correctness, as you well know, and unless, as recognized by the appellate's attorney, unless no reasonable person could agree with what Judge Monaco did, particularly as far as the irreparable harm issue is concerned, then that decision should be allowed to stand.
But if I understand the appellant's position on that issue correctly, it's really an error of law position, that being that Judge Monaco either failed to understand what Ohio law was or failed to properly apply Ohio law to the extent that there is this presumption of actual harm once you prove that the person subject to the non-compete agreement
had access to trade secrets.
We disagree with that interpretation of Ohio law and made that argument to Judge Monaco. I think she's probably right whenever she says that the argument as to joining in OSS in the injunction and the judge's denial of OSS as a party to the injunction, in other words, being made a party to that injunction, is a question of law. I don't believe that her interpretation of that law is correct, but that's where the interpretation is. As far as granting as far as the determination that there was no irreparable harm, that's just an abuse of discretion. There's no difference. The law as it relates to, and we can just go straight to that point, there's several things that Judge Monaco could have hung his hat on as far as making this decision. And that first is that there is Ohio law that says that the nexus between a breach of a non-compete agreement and not having to prove irreparable harm. If you look at the Arthur Murray case that we cited, and there's a great discussion of this, said that's correct if it's a person who is selling a business and giving a non-compete agreement in the sale of that business, because he has a right to protect himself. But he goes on at length, the author of the opinion in the Arthur Miller case goes on, and the Arthur Murray case goes on and says, if you look at this, whenever you're dealing with an employment agreement, the employee may unwittingly sign an agreement for a non-compete because he wants to protect his right to work. He wants to protect his right to provide for his family. That's exactly what happened in this case. If you look at the facts in this case, when you go back, Randall Gray has been in the business of vegetation management all of his adult life. He worked with Nelson whenever Nelson was owned by a fellow by the name of Bloombaugh. And this is all in our brief. Bloombaugh designed
I'm still having a hard time getting my mind around it. Here's what Judge Monaco found. Although there's clear and convincing evidence demonstrating a strong likelihood that plaintiff will prevail on the merits of its claim that the defendant Gray has violated the subject non-compete agreement, the evidence fails to show clearly and convincingly that irreparable harm will result unless the injunction is issued. So it seems to me that the judge, found, that at least preliminarily, going through the steps to see if he can enter an injunction, that he violated the non-compete agreement. So I'm interested in hearing how he cannot find that irreparable harm would occur given the Ohio cases that were cited.
We don't agree with the Ohio cases that were cited. That's where I was in that process. If you will look at our brief, in the discussion that we have on the Arthur Murray case, and the discussion that the judge gave on the Arthur Murray case, it says that's what she says is true whenever someone sells a business, because they have a right to protect themselves in the sale of that business. In other words, they're negotiating an arm's length transaction for the sale of the business, and it says, I'll sell you my business and I won't compete with you. And they say, okay, the court says that's fine. Irreparable harm is presumed under those circumstances. But they also go into great length to talk about the employee cases. It says that people will sign, to protect their jobs, they will sign non-compete agreements in employee situations. What happened with Mr. Gray in this case, he was a manager for Nelson before Nelson was purchased by Osplund, if that's the proper pronunciation, the people with the orange trucks. Osplund bought Nelson. They went to every one of their managers and said, if you don't sign this non-compete agreement, you're not going to be a manager with us anymore. Those were the circumstances under which it was signed. There's no question about that. That's in the record. So Nelson signed the non-compete agreement. Some things happened, which we don't need to get into at this point in time, and he decided that he wasn't going to be there any longer. But that's exactly the situation that you'll find in the opinion in the Arthur Murray case. It says that's why these kind of cases are distinguishable when it gets to the situation of a non-compete agreement.
So you're not drawing the line as to whether your individual client, Mr. Gray, had trade secrets. You're drawing the line that this plaintiff, Nelson, in order to be successful, would have had to show actual proof of harm, competitive harm, by the new company, OSS's use of those trade secrets.
We have two situations, Judge Conner. One is we say that there was no showing of irreparable harm, and they had to show irreparable harm, and that's what Judge Monaco found, and that's the reason I believe he denied this injunction. The second point is, though, also that there was evidence before that court that all of these things that they call trade secrets, it pre-existed Nelson. They were out there in the public domain. These regional field production report, according to the testimony, or there was testimony, that was designed by this fellow Bloomball that owned Nelson before Nelson was sold to Osplin. The rate buildup sheet was there before Osplin bought Nelson. So that's not a trade secret.
All right, so you do dispute.
We do dispute both of them.
This guy
I
had
mean, we
any
did both
trade secrets.
well, in before the trial court. So those are both at issue.
Can I ask you, Mr. Ireland, about your reliance on this Arthur Murray case? I found it in your brief now.
Yes.
Your brief indicates that's a 1952 Ohio Court of Common Pleas decision.
Yes.
Now, I'm not an expert on Ohio law, but isn't the Court of Common Pleas a trial-level court?
I don't believe it is. I think it's an intermediate. It's the same. I think it has the same status at that point in time as this court does. Whenever I went back through, and I can certainly stand to be corrected on that.
Well, the reason I ask you that is because there are a whole bunch of decisions that the appellant cites, both from the intermediate appellate courts in Ohio that are much more recent. One is a Procter & Gamble case. It's a 2000 case from the Ohio Court of Appeals, and also cites a whole bunch of cases from the United States Court of Appeals from the Sixth Circuit that are relatively recent, applying Ohio law that seem to be to the same effect. And I'm wondering whether maybe this Arthur Murray case is just the ruminations of a single trial court judge. But I guess if you don't know the answer to that, we can look it up.
I do not know the answer. I'll be happy to find that out for the court. But I would also direct you to the Janoco versus Infocare case, which is a 2006 Ohio appellate decision. It's found on page 15 of the brief and several other places, which is about to the same. It doesn't go into the same depth as the Arthur Murray case does, but it deals with the same thing. Or the Kerry Linder case, which is a 2002, found on page 19 of the brief, that deals with the trade secrets issue and finds that the Kerry asserts that Linder misappropriated trade secrets such as pricing structure, profit margins, cost, and customer information. It goes into the same detail there. The Arthur Murray case is the only one that I could find that distinguishes the employee-employer situation from the seller and buyer with a non-compete agreement situation. And on over to, well, that's the Arthur Murray case. There's another case that's out of this court, the McCumber case, which cites a Troy case out of Alabama. This finds, I think, in the McCumber case, it dealt with things that were in the public domain, such as what we contend in this particular case, the information which Nelson wants you to believe is trade secrets. Just by calling it a trade secret certainly doesn't make it one. What you're dealing with here are bidders. If they bid a job for example, City of Gainesville Utilities, Tallahassee may have public utilities. When that bid comes in, that bid is in the public domain. Any bid that they do for a governmental agency is in the public domain. Every bit of the information that they want you to believe are trade secrets is put into the public domain whenever they start going into this.
But that's because of Florida's strong sunshine laws, isn't it?
Exactly.
It wouldn't apply in private business relationships.
Not in private business relationships, but a good majority of these public utilities that they do work for are public. They're the public. I think the last thing that I can touch on, and then I'll sit down, is the issue of whether OSS should have been enjoined, if anybody's enjoined. Once the court found that there was no irreparable harm, I don't think it needed to get to that issue because they don't enjoin anybody. But we've given you some cases in there, and the pleadings, the status of the pleadings in the case are that there were 2 counts against Randall Gray, 1 count against OSS in the complaint. They were all joined in the same complaint. The injunction count was against Randall Gray only. There was a damage count against Randall Gray, and then there was an account for torturous interference with business relationship against OSS. That's the way the pleadings
Let me ask
were.
you another question then about this. I'm really curious about this about what the trial court had in mind when it found likelihood of success but no irreparable harm being shown. I'm having some difficulty with your argument, they didn't even prove use of trade secrets. And in this case, the various trade secrets were the bidding methods. I think there was something, there may have been something about customers and that sort of thing. Is it your contention that, it seems to me, if you carry the thing out logically, Mr. Ireland, that if it's a given that the covenant not to compete was violated, but there was no use of unfair, what used to be called a common law unfair competition, there would be no damages in this case. So how does that reconcile with the trial court's finding of likelihood of success?
I don't think the trial court got that far. I think the trial, and what the trial court said was that there's substantial likelihood of proving that Randall Gray violated the non-compete agreement. That doesn't go then to say, and as a result of that, Nelson was damaged. There's no, there can't show, and I think I said
So you don't read that as a bad sign for the future of this case?
I don't know about the future. I'm just worried about what's happening right now, Judge Cox. But you get to the point, and we put it in there. This is a bunch of folks that are out there bidding on jobs. There's nothing that says that just because OSS bid and got the job, that if OSS had not bid, Nelson would have gotten the job. There's no showing of that. And that may have been what was in Judge Monaco's mind. Unless I can answer any more questions, I'm sure.
Thank you.
Thank you.
Let me jump you with where I left him, because this Ohio law, the Levine case, and the other cases that you rely upon seem to suggest that if you have trade secrets, and you go to work for an employer, you go beyond a presumption. You've proven your case. You've proven your case.
Correct.
But Mr. Harlan is now arguing that he didn't even have any trade secrets. Is that still an issue in this case?
Because of the ambiguity of the court's ruling, perhaps it's still an ambiguity, although I'll point out, Your Honor, that in order to find a likelihood of success on the merits in the very first place, the court had to look at the following factors. One of those factors is whether the employee possesses confidential information or trade secrets.
Well, that's the way I read the order also, but he argues that, well, it's substantially likely that you'll prevail on the claim that he violated the covenant.
And you can't violate the covenant unless the covenant was reasonable. The covenant can't be reasonable unless it protected a trade secret. I, of course, agree with you, Judge Kahn, and believe that the court was finding without stating that there was a trade secret at issue in this case. Because there's a trade secret, the law of Ohio is clear with the absence of the Arthur Murray case from 1952 that we have proven irreparable harm. In the Arthur Murray case, it's extremely lengthy and was written in some archaic language. However, if you read it, it does not disagree with what we've been saying. The Arthur Murray case says specifically that the great weight of authority holds that if an owner of an established business sells it and enters into a reasonable covenant not to compete with the buyer, irreparable injury will be presumed from the mere violation of the covenant. This case has nothing to do with a mere violation of the covenant. Ohio law since 1952 has developed to state that in a situation where an employee leaves an employer's employment, goes to work for a competitor, and has knowledge of trade secrets, you've proven it. The Arthur Murray case had nothing to do with an employee having knowledge of trade secrets. So it's very distinguishable, notwithstanding the fact that it has been obviously later courts in Ohio, more senior courts, have found directly that it is proven in this type of situation. And for those reasons, we would ask this court to reverse the lower court's holdings on both counts.
Thank you, Ms. Lyons.
Thank you.
This court is in recess until tomorrow at 2 p.m.